following is a project of our nonprofit newsroom. Support Midcoast Morning and local community-centered journalism today by signing up to be a monthly sustaining donor at chuy.ca/donate. It doesn't take much money to support local news.
Hello and welcome to Midcoast Morning. I'm Joe Pugh. The Palestine Solidarity Encampment has been cleared off the grounds of VIU following a Sunday deadline set out in an injunction from the BC Supreme Court. The encampment had been up since May 1st, and several media outlets had described it as the last Palestinian Solidarity Encampment remaining on a Canadian university campus. The terms of the injunction granted differed from those originally sought by the university, which would have included a campus-wide curfew and police enforcement terms. Instead, the injunction grants the university the right to remove, store, or destroy materials on the grassy portion of the quad near VIU's cafeteria for a term of 150 days. It also forbids the erecting of structures on the grassy quad area without the university's consent, as well as gathering on the area between 11 p.m. and 7 a.m., with the exception of students living in residence. The BC Federation of Students, which was an intervenor in the court case, released a statement this week saying it applauds the steps taken by Justice Michael Stevens to narrow what it described as the far-reaching injunction sought by VIU. Another intervenor in the case was the BC Civil Liberties Association, which said in a statement that it has become increasingly concerned with injunctions being used to restrict protest rights. For more, I spoke with Gaw Grant from the BC Civil Liberties Association.
I'm Gaw Grant, and I'm Staff Litigation Counsel with the BC Civil Liberties Association.
And what did you make of the ruling in the case between VIU and the Palestinian Solidarity Encampment on its grounds?
Well, I guess there's two parts of our reaction. There's a good part of the ruling is that the judge did not grant the full scope of the injunction that VIU was seeking. VIU was actually seeking, to have a full curfew overnight across campus. They were seeking to have police enforcement terms so that police could come in and enforce the decision. And they were, hoping it to be this injunction that would be all across their property. And the court agreed that that was overbroad. So we're glad to see that part of the decision because it was covering aspects of students and other people who might be on campus activity that is not really part of the encampment. And we are glad to see that the court recognized that there was no evidence that police were necessary to enforce the injunction, because it's always concerning when police can be enforcing injunctions against protesters. We can see a lot of excessive use of force. So that can be concerning. So we're glad to see those aspects of the decision. But we were disappointed that in this case, the court didn't take into consideration the charter rights of students. Everyone has charter rights under Section 2B and C of the Charter. That's the freedom of expression and the freedom of assembly. And they're really important democratic rights. And so we were pushing the court to evolve the law in this area to make sure that those rights are going to be considered. And we didn't see that happening in the court's decision, so we were disappointed by that.
Speaking to Canadian Lawyer, you said that injunction law was not created to be used in the context of policing protest rights. Could you tell me about that idea?
Yeah, so injunctions were created, injunction law was created to address situations really between private parties. So, between company A and company B, what's going on in their dispute, or kind of in these contexts where there's something specific that is a harm that's happening. And until there's a trial where we can really determine on the merits what's happening here, and the court can make a decision, we're going to say that something needs to be stopped or ordered in the meantime. And it wasn't really designed to take into account aspects of public law, which would include constitutional rights, like our charter rights. So the analysis is not clear how to take account of that. And it doesn't really do that. And the result is an assessment that isn't looking at how our charter rights are being impacted. So that's why the BC Civil Liberties Association was intervening in this case, because it's not just about this specific encampment where we're seeing an injunction being used to suppress protest rights. We're seeing this being really frequently used because it's essentially become a very easy to access tool for whoever is being protested against, that they can go and seek an injunction. And because the analysis isn't really looking at how it's suppressing charter rights, then it's unfortunately becoming very easy for them to access to suppress our charter rights. So that's why we were intervening, that this area of law needs to evolve.
Can you give me a sense of what some of the other instances of the kind of thing you're describing that have happened are?
We saw injunctions, for example, being used against protesters at Fairy Creek. We've seen it be used by the Vancouver Port Authority against protesters there in recent times. We've, of course, seen with the Palestinian Solidarity Encampments across Canada that there have been different universities that have tried to seek an injunction against student protesters. But it can also crop up into even smaller scale protests that may be less on the news. I was hearing the other day about in Souk, for example, a First Nation accessed an injunction against people that were protesting against something they were doing. So it really can be used in a wide variety of contexts where people are protesting.
And your issue, the BC Civil Liberties Association's issue, is that the specific mechanism of deciding on whether or not to grant an injunction you feel doesn't take into account people's charter rights?
Exactly. It doesn't take them into account. I mean, obviously, being able, in our legal system, property rights have an important place. But should that override our constitutional rights? Property is not in the Canadian Constitution. And that was a choice that, the drafters of our Constitution made. And instead, the pillars of our democracy are around freedom of expression and freedom of assembly, because this is how people can participate in democracy and make change and hold our government accountable, hold our institutions accountable. So the fact that this analysis allows property rights to just completely override our charter rights is really concerning. It's not really in line with our Constitution. We have decisions from the Supreme Court of Canada that say that because freedom of expression is so important to our democracy, there shouldn't be anything in the law that restricts that without that, being considered and justified. And the issue with the way injunctions are being used in protest law today is that because they're not considering the impacts on charter rights, they're not providing a justification for it. So we're not saying that that charter rights should always win, because there are cases when our government or our law need to put restrictions on freedom of expression and assembly, but those need to be justified. They need to reach like a high enough standard that it's in the interest of our democracy to have those restrictions. And so the fact that the law isn't doing that in this area is not really aligned with the values of our democracy, and that's why we're urging the court to. And we will continue to intervene in other cases to urge the court to bring the law of injunctions into alignment with our constitutional values. So what is the current test that in these cases is being used as to whether or not I will grant this injunction? Okay, so the legal test in normal cases for granting an injunction, the leading case is called RJR McDonald. And in this case, the VIU is actually arguing that RJR McDonald didn't apply to them, and they didn't even have to do some of the elements of this test under trespass law. And the court disagreed and said, no, RJR McDonald is the test that applies. So it has three parts. The first part is that a party has to demonstrate that there's a serious question to be tried. So it has to be an important issue, not something frivolous. But, this is just a preliminary assessment because the court isn't going to be doesn't have all the evidence that you would have in a full trial. The second step is, and the part of that is the irreparable harm. So you have the party seeking an injunction has to show that if the injunction was not ordered, that there would be irreparable harm against them. So some kind of harm that would not be possible for to undo, basically. So that's an important stage of the package as well. It could be money, this kind of irreparable harm, or some other kind of damages. And the third step is balance of convenience. And so this is kind of more of the weighing category, and saying, weighing the question, if we grant the injunction or if we don't, whom will suffer more, and where will the more harm be likely to lie? And you can see the fact that if that doesn't consider charter rights, then what is the harm? Because that is the harm. So if the analysis isn't going to consider charter rights, then you're not really going to be weighing against very much. So that's kind of the three-part test, and the BCCLA was making really specific suggestions to the court about how charter rights can be incorporated into this assessment to make sure that those rights are going to be understood as part of the harms that an injunction would have. In this case, because the court was just applying the regular RJR McDonald test without doing a charter analysis, because he said the charter would not apply to the university.
I'm curious as well maybe when it comes to irreparable harm, something like an institution saying, well, we've had to, or even the way I phrase that sentence, we have spent this much money on, say, security or a public relations firm as a result of this encampment. Like, how does something like that factor into presenting this as harms in court? Exactly.
So that was part of the harms that VIU was arguing they had suffered, is because they paid, I think the figure was $870,000 for PR and extra security costs. Of course, part of what the defendants raised is, well, are these costs disproportionate to what was actually happening? If you don't really have any real threats to security, or there's no threats of violence, something like that, then these costs are they just costs that you're choosing to undertake? And at this stage in the injunction analysis, the court was just like, well, some of the costs could have been reasonable, and therefore that's the harm, and just kind of let it be like that.
And again, I would imagine the very nature of an injunction is that it's sort of like it happens quickly, with the maybe sort of codified, correct me if I'm wrong, in the actual law intention that probably doesn't happen in these cases, that down the road there will be like a more fulsome trial, correct?
That's the idea, that it's meant to be, between two parties, a really quick access to remedy because there's an emergency. With the hearing down the road. But what we see in the protest context is there is no hearing down the road, because the only thing that the party seeking the injunction wanted was an injunction. And so you can imagine being a defendant on something like this, where you have 2 weeks to 2 weeks is almost on the better end of how things could be. It could be as soon as tomorrow, the hearing that is thrust upon you, and you have to get counsel, and you have all this evidence coming against you, and not a lot of time to be able to really interrogate that evidence, how necessary it is, and provide a case against the injunction, and explain the impacts on your charter rights.
So what's the solution going forward? Like, what would the BC Civil Liberties Association in an ideal world like to see instead? Is there like some kind of other legal mechanism you think we need to develop to handle these cases?
Yes. So the way our injunction law is right now, it's really unfortunately evolved to become something easy to access for parties that are being protested against, which in our society is frequently parties that have power. And it's not taking taking account of our charter rights. So this law needs to evolve. We need to be able to have the framework of injunction law take account of our charter rights, and make sure that any restriction on them conforms to the standards that we have in constitutional law around proportionality and necessity. Is it necessary to be restricting these charter rights? Is it proportional to what's happening and the degree that those charter rights would be restricted? Those are questions that we think the court should be answering.
Is there anything else you think it's important for people to know about this decision?
I think it's important for people to know that while the court declined to make a decision about evolving the law in this case, that the door is left open. And if you care about your charter rights for anything that you would want to protest, and for the role that would have in our democracy, then it's important to understand this area and to know that we, at the BC CLA, we're going to continue to be working for the law to evolve, to make sure that our charter rights can be considered and justified in the future.
Gaul Grant, thank you so much for taking the time to speak with me.
Thanks, Joe.
Gaul Grant is Staff Litigation Counsel with the BC Civil Liberties Association.
Midcoast Morning is made possible by the Community Radio Fund of Canada's Radio Meters program and listeners like you. Support Midcoast Morning and CHOI's nonprofit newsroom today by becoming a sustaining donor at choi.ca/donate. Local news can't survive without your support. Another way to help us out is to share this show with your friends and tell them why they should support us. Finally, if you're listening to the podcast edition of Midcoast Morning, go and give us a positive review on Apple Podcasts or whatever podcast feed you use. It helps people find us.
This past Sunday, the Palestine Solidarity Encampment on the quad in front of the library at VIU was cleared following a deadline set out in an injunction granted by the BC Supreme Court. On today's show, we're talking about the process of getting to that injunction. The BC Federation of Students was an intervenor in the case. I got in touch to speak about their reaction to how it played out.
My name is Jessie Nicoy. I am the chairperson of the BC Federation of Students, and I'm joined by...
My name is Ariel Reed, and I'm staff here at the BCFS, and I'm the researcher.
And what was your reaction to the way this court case around the Palestine Solidarity Encampment at VIU wound up?
As an organization, or as an organization that represents members, I think for us, we consider this a win because according to what came out of the case, the institution was being far-reaching in terms of having all the things they wanted would have had a negative impact on their members. So for us, the way it concluded is that students were able to have their rights protected and that they would be able to have that freedom of expression on campus that they need to be able to express themselves on things that are important to them.
Could you go into more detail on what some of your specific concerns were with the order that was originally sought by VIU?
Yeah, so we realized that in the injunction, one of the things was there was going to be a curfew on campus, or they wanted a curfew on campus between the hours of 11 p.m. and 7 a.m. So that would not only affect the people in the encampment, but it would also affect other students who would be accessing other services. So one of the things that we were asking for was for that to be it's far-reaching, or mentioning that it is far-reaching and the judge or the court has to do something concerning that. And also just the basic thing, or the key thing, was as an organization that defends and fights for the rights of students, we felt like there was going to be not only restrictions on students' rights to freely express themselves, but also just the whole community, because the restrictions were not going to only affect the encampment people, but was going to affect the larger campus community. And what we wanted to do as interveners is bring that perspective that students need to have that freedom of expression and be able to freely express themselves, and the institutions have to take up that mantle of balancing that space that they provide for students to freely express themselves and also just provide the education that they want to provide.
So ultimately, the encampment did have to move away from the space in the quad. What do you make of that when it comes to what you've talked about there of students' freedom of expression?
I think for us, we're looking at the big picture in terms of, for that campus space, the effect that it would have had on their members. So we're very thankful to the VIU Students Union for reaching out to us to be able to bring that perspective of the negative impact it would have had on their members and also on the campus community. So for us, it is making sure that institutions take up that mantle of providing that space for their members to be able to freely express themselves, and also just students being able to access the campus that they need to be able to get the education that they want to. I don't know if Ariel wants to add anything.
I think, looking at this in a broader context, in the context of, what has been happening on other campuses around the country, the precedent that VIU was really focusing on was what happened at U of T. From our perspective, the conditions that were there for the injunction being granted at U of T were not the same conditions that were at VIU. And at VIU, what we saw was that dialogue piece wasn't there, and that the injunction represented a heavy-handed response when collaboration and conversation hadn't been established at the base. So, the question as to, how we feel about, the injunction being granted and that the PSE encampment is going to be taken down. It's like, we run the risk whenever we go to places like courts of law for people to end up with results that they don't like. Courts aren't made to make both parties happy. But what we did see and why we consider this a win is really because it demonstrated that the unique nature of universities and university campuses, which is to provide an important venue for the pursuit of knowledge, acting on that knowledge, and where student participation in democratic and civic life is part of the education experience, that was recognized in a court of law.
Your statement on this that came out Monday mentioned what you described as a troubling pattern of behavior from VIU. Can you elaborate on that?
Yeah, and I think just taking information from what the Students' Union actually reached out to us about as well. Earlier in the year, there was the VIU took actions against members across the campus where they had to provide identification before being able to access buildings. So just highlighting from that part, we've seen the breakdown in the relationship between the institution and the Students' Union, and not only that, but just with its members. So the reason we took up that intervenor status, or just taking part in this case as intervenors, was to make sure that we're protecting the rights of students, not only the people on campus, but the whole community as well, because we're not only focusing on students that are currently there, but students that are also going to come to that campus later should they choose to.
Have you heard anything about if and how the relationship between the university and its students has been impacted by everything that's gone on, and if so, what the path forward might be?
I think for our organization, we haven't really heard anything. We do think there's going to be further communication with the student union itself to see how the relationship is going to be moving forward. But we do hope that the institution actually works together and collaborates to make sure that they're providing the space that they need to be able to make sure that students are able to access the campus and also take part in any future protests, that they can speak or have that freedom to express what is important to them and what their views are, because that is the essences of going to institutions. You're learning and applying what you are learning. So students need to be able to have that space to apply what they learn should they choose to.
I'd like to point out, if I may, this is Ariel again speaking, that the VIU library at some point was open 24 hours, during the exam period, kind of at the for part of the semester, understanding that the nature of finals requires people to access libraries and access educational institutions in an extraordinary way for this particular period. It is our understanding that 24-hour status for the library has not been restored. And for us, again, institutions need to manage their desire to have things run smoothly on campus, with the unique nature of universities, and the services that they need to provide for students in order for them to be successful. So for the institution to really describe the PSE encampment, as we had seen on its website, as like calm, as like not dangerous, as basically students peacefully exercising, their right to express themselves, and then to have, a service like the library not open 24 hours during an important period. The question for us is, well, is that a measured and justified response to a situation that might make people feel uncomfortable? And from our perspective, that measurement needs to happen in order for institutions and colleges and universities, for students across BC and across Canada, to be active agents in their educational pursuits, and to be part of the campus community and really talking about the things that are important to them, and having a responsive administration that is able to pivot to listen, to engage, and to pivot to make sure that folks have what they need to be successful in their education.
Jessie Nicoy is chair, and Ariel Reed is a staff member with the BC Federation of Students. That's our show for the day. Thank you for joining me. I'm Joe Pugh, host and producer of Midcoast Morning. Jesse Woodward is our executive producer, and RB Frew is our technical advisor. You can sign up for CHLY's newsletter at chly.ca/subscribe for updates from our nonprofit newsroom and more. Our theme song is First One by local Nanaimo band Waste Management. If you have a story you'd like us to cover, email us at news@chly.ca. That's all for now. I'll talk to you on another Midcoast Morning.
Midcoast Morning would not be possible without the funding of the Community Radio Fund of Canada's Radio Meters program and listeners like you. Midcoast Morning is a project of CHLY's nonprofit newsroom. Support nonprofit journalism in Nanaimo and on the Salish Sea today by becoming a monthly sustaining donor at $5 or more per month. Support the program at chly.ca/donate. If you're already a supporter, record a voice memo telling others where you're listening from and why they too should support our work. After you're done, you can email it to us. Also, share the podcast with your friends. While Meta is blocking Canadian users from sharing news content on their Facebook feeds, you can still share our podcast directly with your friends via Facebook or Instagram Messenger. Finally, this program acknowledges and gives thanks to the Snuneymuxw First Nation as we broadcast and podcast from their traditional territory. Thanks for listening.